So today I will be explaining about copyrights, patent, and trademarks. So here's a short introduction to that. Trademark. A trademark is a type of intellectual property consisting of a recognizable sign, design, or expression which identifies products or services of a particular source from those of others. In simple words, trademark is a sign, logo, design, or sentence which represents a company or something, some services. In simple words, copyright refers to a legal right of the owner of the intellectual property. In terms, copyright is right to copy. This means the original creator of products and anyone they give authorization to are the only the ones with the exclusive right to reproduce the work. So the owner of the particular service who allows someone other to copy their work is what a copyright it is. So a patent is a form of intellectual property that gives its owner the legal right to exclude the others from making, using, and selling and importing an invention for a limited period of years in exchange for publishing, enabling public disclosure of the invention. In most countries, patent rights fall under civil law, and the patent holder needs to sue someone infringing the patent in order to enforce his or her rights. So, what is a trademark? Trademark is a brand. Although trademark used to identify services are usually called service marks, a trademark owner can be individual, business, organization, or any legal entity. A trademark may be located on a package, a label, a voucher, or any other product itself. For sake of corporate identity, trademarks are often displayed on company buildings. It is legally recognized as a type of intellectual property. The essential function of a trademark is to exclusively identify the source of origin of product or services. So a trademark, a property properly called, indicates a source or serve as a badge of origin. In other words, trademarks serve to identify a particular entity as the source of goods or services. The use of trademark in this way is known as trademark use. Certain exclusive right attached to a registered mark. A trademark are used not only by business but also by non-commercial organizations and religions to protect their identity and goodwill associated with their name. Types of trademark: word mark, figurative mark or logo type, three-dimensional mark, sound mark, motion mark, multimedia mark, hologram mark, position mark, pattern mark, and etc. Copyrights. Copyright is intended to protect the original expression of an idea, a form of creative work, but not the idea itself. A copyright is subjected to limitations based on public interest considerations, such as fair use doctrine in United States. Some jurisdictions require fixing copyright works in a tangible form. It is often shared among multiple authors, each of whom holds a set of rights to use or license the work, who are commonly referred to as right holders. These rights frequently include reproduction, control over derivative works, distribution, public performance, and moral rights such as attribution. Copyrights can be granted by public law and are in that case considered territorial rights. This means that copyrights granted by the law of certain state do not extend beyond the territory of that specific jurisdictions. Typically, the public law duration of copyright expires 50 to 100 years after the creator dies. Depending on the jurisdictions, some countries require certain copyright formalities to establishing copyright. Others recognize copyright in complete work without a formal registration. The following types of work allowed to protection under the copyright law. Literary works. This can include novels, non-fiction works, poems, articles, essays, directories, advertising, catalogs, speeches, and computer programs. Musical works. This category includes both the musical notation and accompanying the words, some melodies, etc. Dramatic works. This type includes plays, operas, scripts, screenplays, and any accompanying music such as movies, some scenes. Pantomimes and choreographic works. Popular dance steps are not included in this type of work. Motion pictures and other audio-visual works. These include movies, videos, and film strips. Pictorial, graphic, and sculptural works. Works included are sketches, drawing, cartoons, paintings, photographs, slides, greeting cards, architectural and engineering drawings, maps, charts, globes, sculptures, jewelry, glassware models, tapestries, fabric designs, and wallpapers. Sound recordings. This include recording music, voice, sound effects, thunder, animal noises, and other sounds of nature may be copyrighted by the persons who recorded them. Compilation. You can put together a compilation or a collection of existing materials, and the collection as a whole can be copyrighted. Some example would be a book of poems with written about trees, or a list of best cancer doctors in India. So next is patent. The procedure of granting patents, requirements placed on a patentee, and the extent of exclusive rights vary widely between countries according to the national laws and international agreements. Typically, however, a patent application must include one or more claims that define the invention. A patent may include many claims, each of which defines a specific property right. The claim must be relevant requirements such as novelty, usefulness, and non-obviousness. Under the World Trade Organization's TRIPS agreement, patents should be available in WTO member states for any invention in fields of all technology, provided they are new, involve an initiative step, and are capable of industrial application. Nevertheless, there are variations on what is patentable subject matter from country to country, also among WTO member states. TRIPS also provide that the term of protection available should be minimum of 20 years. So that's how a longer patent is. It takes 20 years to expire a patent. There is now types of patents. Utility patents in most common type of patent that people seek. In this type of patent covers processes, composition of matter, machines, manufacturers that are new and useful. Design patents. Design patent is defined as surface ornamentation of an object, which can include the shape or configuration of an object. In order to obtain this type of patent protection, the design must be inseparable from the object. Plant patents. A few requirements to obtain this type of patent are that the plant is not a tuber propagated plant, the plant is not found in an uncultivated state, and the plant can be asexually reproduced. Thank you.